Move to Doug in Carlton. And Doug says a Michigan purchaser wants to know, how do I get a seller disclosure on a property I closed on? And that's all that Doug in Carlton has to say. A Michigan purchaser wants to know. Doug, are you the Michigan purchaser?
Yeah.
Asking
So this,
for a friend.
okay, right, a Michigan okay, so this happens quite often when people are dealing with properties after they purchase them, they've closed on the home, and or a commercial piece of property, but a disclosure or any type of real estate document will probably be, and most likely be, obtainable by just reaching out to the title company. So if you close your transaction with a title company, the title company will have all the closing documents, okay? However, on a residential piece of property, a title company may not have all of the real estate transaction documents, what led up to the closing, okay? And that can be difficult sometimes, that people walk away from their closing and think that they have everything from their transaction, from the day that they signed a listing with their realtor to the day that they close. They think they have everything. And when they come to people like myself, attorneys like myself, when there's an issue or problem with the house, invariably we get the closing package and the seller's listing agreement, or the buyer's purchase offer and the seller's disclosure statement, which is what they're requesting. That's not in there. So where is it? Well, right now, just in modern, business these past several years, you should look first of all to DocuSign or HelloSign. Most of these documents are transmitted electronically. So if you go through your email, you should be able to find it or locate it. And if you can't, you should pick up the phone and contact your realtor. Now, a lot of realtors want, okay, I'm gonna, you know me and realtors. I'm a licensed real estate broker for over 20 years, and full disclosure. And I always say this because it should be said, there's great real estate agents out there, but there's quite a few in the business that once the transaction, and it's like any professional, but once the transaction is over, the parties to the transaction never hear from their real estate agent again, okay? It's just unfortunate, it's a sad part of business, but it does happen. So you may, as a buyer or a seller, reach out to the agent and the agent's not returning the call. Well, who's going to have these documents? The real estate broker. Your real estate broker or the broker for the other side should have a copy of the complete transaction documents, because there is possible liability, legal liability, that these brokers have to protect against. So they have to retain the documents in a compliance repository. I think it's up to 5 years, but don't quote me on that. And I'm sure somebody will write in a comment, no, David, you're wrong, it's 3 years or 7 years. Okay, I don't commit that to memory, but the broker has a place where they're holding on to these documents. Usually it's online. And this is frequently occurs if you look at your final settlement closing statement or your final title statement. It will show you that the buyer, usually the buyer, yeah, I mean, it goes both ways, but the broker will be charging one of the parties a compliance fee. They call it a compliance fee. Well, what is that? That's a fee to hold on to the documents. And that's not a cheap fee. And it's like usually around, it can be $150 to $350. If you agree to pay $350 for somebody to hold on to your documents, well, I mean, you should negotiate that before you even close the deal. However, nonetheless, somebody has those documents. Pardon me. And if you have to have a lawsuit, let's say it's a home seller non-disclosure issue, meaning the seller failed to disclose something about the condition of the property at the time of sale. Now the buyer's got to go and bring a lawsuit, and they may not have a copy of the home seller disclosure statement. Where is that statement? It's somewhere. It's going to be in the closing package, or it's going to be with one of the real estate agent's brokers, okay? And if you can't get it, then we subpoena for it once there's a lawsuit, okay? And the brokers and the agents have to provide it. Now, there's always the risk that nobody has a copy of that document, which is really good for people like me, because if you don't have a copy of a signed document, there could be problems there as well. Okay. But in general, I think his name was Doug.
Yep.
You're looking for the documents. If neither the agent or the title agent has the document, then you're going to have to probably, engage an attorney to get those documents.
Okay. All right. Okay, moving on to our next question. It must be from Anonymous because we don't have a writer. So we'll just say Anonymous asks, do banks require that a co-signer be part owner of the second property as well? Would forming an LLC with the other individual help from becoming a co-signer? And that's the entirety of the question.
And that's why there's no writer on that. But I think I know what they're asking on that one. Okay. First of all, in general, banks love co-signers, right? If you co-sign on a mortgage or any type of loan agreement, you don't have to have a real interest in the property.
Okay.
But when it comes to real estate, most banks want the parties who are on the loan agreement to have a vested interest in the property. I actually know that question. That's why I could jump right into the answer. Okay. These people actually are really not, they call themselves co-signers, but really what they were guarantors, okay? And you know the difference between a guarantor and a co-signer?
No.
Well, not much. There's not much of a difference. A co-signer usually is somebody on a loan agreement, though, who's actually on a loan application. So you and I could go to the bank and we could borrow money, and we would be co-borrowers and we'd be co-signers, okay? Now let's pretend you go to the bank and you get your own loan, but the bank says, we really like you, Blair, and we know that you're very active in the real estate market. We trust you. We just need a little bit more security. And do you have a friend or somebody who, is credible, like David Sobel, who would maybe co-sign or be a guarantor for you? So a guarantor does not have to have an interest in the property. Okay. Got that? So lawyers call, well, I don't know if all lawyers use this terminology, but the people who taught me, my mentors, basically said to me one day, you know what a guarantor is, David, don't you? And I said, I don't know. They sign on behalf of somebody else. And they're like, no, a guarantor is an idiot with a pen.
Yep.
Yeah, being a guarantor is not a great situation. You have to have a lot of faith in your borrower. However, I know we're going to go down a quick slippery slope. You can curtail the obligations that you may have as a guarantor. And there's a number of different ways to do that. Too long for us for discussion tonight. And you're probably sighing there, Blair, like, oh, good. But if you can go to our website at provenresource.com. We have a whole article on how to change, reduce, modify, limit your legal exposure and financial exposure as a guarantor. Okay?
Okay.
But a co-signer and a guarantor are very similar.
Okay.
Got that?
So to answer this person's question, the second portion of their question is, would forming an LLC with the other individual help from becoming a co-signer?
No, I didn't understand that part, but they're just trying to not hide, but put an extra layer between their personal liability to a bank and, their corporate liability.
Okay. Yeah, so it seems like this question is, there is someone who wants to help out, but wants to keep it kind of at arm's length a little bit,
Right.
Responsibility, liability, etc., which I don't blame them. So the last time I had a co-signer was student loans, like my parents co-signed my student loans, but outside of that, I've never had a co-signer, especially for any real estate purchase. So that's not anything that I'm aware of anyway.
Here's
I don't
the thing about the co-signer. So like when your
Mhm.
parents co-sign for you, this goes to the illustration of, you know, they're really co-applicants. Somebody looked at their financial and credibility and their financial wherewithal when they made the loan to you, Blair, let's say for your student loan. They still
Mhm.
look to your folks. So the co-signer is somebody, from my perspective, is somebody who's still, they may not have to make a complete application, but they do have to be verified in their borrowing ability. You know, are
Mhm.
they going to be a good debtor? That's what a co-signer is. And the guarantor is just one more person removed. We don't care who the guarantor is. If they, you know, most banks would just say, oh, you can guarantee if you have a house, maybe some money, but we're not going to really qualify you. If you want to stand up and step into the shoes of the borrower, go right ahead. That's the
Okay.
difference.
Okay.
Okay.
All right.
I do have one more comment though.
Mhm.
If a loan is taken out by a limited liability company or an S corporation, pardon me, a C corporation, sorry about that. The corporation is the primary borrower. Then what a bank will do, however, is then make the individual a guarantor.
Mhm. Okay.
The individual who actually has an interest in the company.
That makes sense.
Okay.
Okay. All righty. So does that answer the question then? Do banks require that a cosigner be part owner of the secured property as well? Is that a yes
No,
question?
no. It depends on the bank.
Okay.
Depends on the bank.
Okay.
I mean, like I said, in the beginning, most banks would like to see that they have a vested interest
Mhm.
in the property.
Okay.
Doesn't mean all banks.
All right. So the answer is it depends,
Mhm.
and maybe they need to shop around.
Good for you.
Maybe. Okay.